we were intoxicated. It's her fault. That was what she did to me. You had the audacity. How do you give that back to her? And you're responsible for that. But you were on probation with this, then you committed this offense?
Everything is always about him, and he calls her the little accuser.
Sir, this is her time to speak. You can leave now.
I guess it got a little too real for the defendant. There's a reason the law says that 19-year-old adults can't drink. It's not that 21 magically makes anyone smarter, but the law's got to draw the line somewhere. This is what happens when a young adult still learning her boundaries and limitations meets a man who doesn't have any. This creep used his own adult daughters to unwittingly lure a 19-year-old victim to his creepdom of horrors for a party. How does a man even look his daughters in the eyes again after that? Let's roll, Ernest.
And 25 CR 349 is called the State of Texas versus Daryl James Ardoin. That's you, present with Mr. Dusler, your attorney, and the state's attorney. Earlier, you pleaded guilty to the second-degree felony of a sexual assault. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Your Honor, there are no corrections or changes concerning the defendant's version of it. He does have a little bit of dispute with some of that, the police version, but
Yeah.
it's basically just a difference of opinion. So I'm going to say we have no objection.
All right.
I have no objection, Judge.
All right, then it is made part of the record for all purposes here. And again, the agreement, whatever sentence shall not exceed a cap of 5 years imprisonment. So it's a second-degree felony. So it can be no less than 2 nor more than 5 years. A deferred or unadjudicated probation can be allowed. Is regular probation allowed under these under this set of circumstances?
It does not apply on limitation on judge ordered. Does not apply to 22011 sexual assault.
Does everybody agree with that? So it's deferred or unadjudicated probation
Judge can't give him straight probation.
or flat prison time. So that's regular probation is not allowed. You're up section what now?
42A.054
Of the Texas Code of
Code of Criminal Procedure, yes, sir.
Article 42853, which is the judge-ordered community supervision,
Can't get
which is regular probation, does not apply to, and we look at section 22.011 Penal Code sexual assault, and that's
A8
yeah,
sexual assault.
that is what was indicted in this case.
Yes, sir.
Go ahead on behalf of defense. You may go
Well,
forward, Mr. Dusler, first. And
We are actually asking for deferred adjudication probation. I have spent quite a bit of time with Daryl concerning this, and he strikes me as a very sincere man who made a very, very stupid decision right before Christmas of last year. As the report indicates, they were having a Christmas party at his apartment with his daughter, a couple of other friends, and the first thing he did that was really, really stupid was providing alcohol for them. They were close to being of legal age, but not of legal age, and never should have done it. And that's the one beginning really stupid thing that happened. After that, he acknowledges that everybody drank way too much, including himself, that there's differences of opinions to exactly what happened. But frankly, he was pretty blacked out himself and doesn't even really recall the exact sequence of events. But he knows that something happened and something happened that should never have happened. He has told me that he totally accepts responsibility for this. He realizes that that was about as stupid a thing as you could do. He's written a letter to the court acknowledging that responsibility. Looking at his history, he's never had any felony of any sort, even accusations of felony. He was on 1 misdemeanor probation, but that was an evading arrest. It really had nothing similar to this type of offense. He's a hardworking young man. He works a full-time job as an operator at a plant. He's got a bunch of children that he supports and pays child support on. Basically, what he's saying is this was just about as foolish a thing as anybody could do. He deeply regrets what happened. In the recommendations, he does say, I'm truly sorry for my actions. I never should put anybody in that situation. Learn my lesson. It should never happen anything like this again. Hardworking citizen who made a very poor decision. And I think that pretty well sums it up. Again, he's written a letter to the court that I've shown Mr. Laird as well. And if the court wants to address him or ask him anything else concerning it, I think I've kind of spoken to the heart of what you told me. He appears to me to be a very sincere man who is accepting responsibility for something that's horrible. And I think that he's asking the court to give him an opportunity to prove that nothing like this has ever happened. Have I pretty much covered that, Darren? Do you want to elaborate or just wait and answer any questions that Judge has for you?
Let me just ask something here. Mr. Ardwan, did you want to say anything before the state? No. One of the things that helps us judges take care of our business is we get the pre-sentence report prepared by the probation office, and they do an outstanding job. I'm very proud to work with them. They help us greatly because there's a lot we don't know. Judges and the lady next door who handle these felony cases, there's a lot we don't know about. We weren't present. So we've got to make an important decision based upon information given to us in spite of the fact we weren't present. And we have to rely on certain methods, and we rely on getting your opportunity to be heard and listening to you. And then the probation office seeks information from law enforcement who do the investigation. And then most importantly, the complainant, the victim in the case. And then they prepare a pre-sentence report. And this one is 1, 2, 3, 4 pages. And it also has a supervision plan for the court to deal with. We have the indictment, probable cause affidavit, all these things that we look at, so that's really some of the first impressions that the judges get is preparing for this sentencing. Each party involved has a chance to speak. You, at your plea hearing, pleaded guilty to this offense that was indicted, second-degree felony of sexual assault, which alleges that on or about December 22nd, 2024, in Jefferson County, Texas, you intentionally or knowingly caused the sexual organ of young lady, to contact or penetrate your mouth without the consent of that young girl. And that's what you swore to and pleaded guilty to. You understand? You were sworn to and you pleaded guilty. So when you go to the pre-sentence investigation, this is what you said. Even though under oath you had pleaded guilty to what the indictment elements were. You say, my daughter and her friends always come to the house. Everyone was drinking. The little accuser, you refer to as the victim in this case, my daughters went to get something to eat and she left her behind. We were intoxicated. Everyone was on the couch. She came, this is the victim, sat on the couch with me. We started fooling around with each other, and I said, no, I'm not going to do that. She, the accuser, the victim, touched me. The defendant, you admitted to being under the influence of alcohol at the time of the offense and explained that you blacked out and don't remember what you did. That's your version, which was, it's her fault. That was what she did to me. But yet, under oath, in front of me, you had the audacity to plead guilty to intentionally or knowingly causing her sexual organ to contact and penetrate your mouth. Oral sex is what you did. That's what you pleaded guilty to. I don't see any of that admission in here. So are you lying to the probation office or lying to me when you pleaded guilty.
No, sir, no. That's exactly what happened. Like I said,
Now, you have two different versions. Which one, if they can't both be right?
When she says that because you were blacked out, you can't dispute that that's actually.
yeah, I think, yeah.
If that's what she said happened, it had to have
Yes, sir.
happened.
That's exactly what.
That's just your version.
Yes, sir.
But when you looked at me in the eye and pleaded guilty, we went over all of this. You looked at me and said, I'm guilty of this. And you were under oath. You're under oath. There's a document that's swearing. You took the oath. You can't have it both ways, sir.
Judge, if I might, state of Texas is not satisfied that he's accepting responsibility for what he's done, and that offer was made upon him accepting responsibility. So we would at this time withdraw the offer and ask this be reset for trial.
Judge, I don't think that the state's offer was contingent upon anything, but I do say that he is accepting responsibility for this. He's saying that he was unconscious. He doesn't know exactly what happened, but he cannot dispute that that's what she says. He said, if that's what she says happened, that's what happened. I may not remember it because I was blacked out, but if that's what she says happened, then that's what happened. And that's the way he's related to me. I think that's
What do you have to say?
that's where we are. And I think the state should be bound by their offer. Because it wasn't contingent.
I think they have a fair issue that's brought up. You
wasn't.
can't have it both ways.
He's accepting responsibility.
I'm accepting the responsibility. And I guess what I told her.
You're accepting responsibility, but you have two different versions.
And say, I was drunk that night. I was out of there.
Who caused that to happen?
I did.
You have, voluntary intoxication is not a defense to any crime.
Yes, sir.
Okay. So that's your problem. You put yourself into. Let me ask you this. How do you give that back to her?
Okay.
And you're responsible for that. I don't even know what the price, you can't set a price on it. One other thing, here before this occurred in 20% point. In your pre-sentence report, you had an evading arrest or detention offense charged against you. It was a misdemeanor, and boom, you ended up being convicted on that crime. You were sentenced to 1 year in the jail. Then you were placed on probation for a year. That looks like it was extended for 18 months. And is that right?
Sir.
Was it 1 year jail, 1 year disposition, 10/9/23, 1 year jail / 1 year adjudicated probation and $1,000 fine, 10/1/24. And then semicolon, 18 months extension. I really don't understand what that means.
Are you still on probation,
Yeah.
Mr. Mayor? You're off.
Yeah, I'm off probation.
When?
Yeah, I get off probation like in February, but what happened on that?
No. When did you get off of probation for that?
February.
This February?
Yes, sir.
You're getting off or you're off?
I'm off.
Okay. But you were on when this happened.
Yes, sir.
But you were on probation with this, then you committed this offense? Okay. Criminal actions have consequences. We made that clear. You were on probation. You were convicted. And so while convicted of this crime of evading arrest or detention, you commit sexual assault. I have that right, correct?
Yes, sir.
The court's going to move forward on this. But
Then, Judge, can I make my argument?
yes,
Before you do that?
yes, sir, you can.
Because I want you to look closely at that letter that he wrote you.
Yes, sir.
Clearing this all up and how much remorse he had and what he did to her, because that letter is all about him, all about everything is always about him. Even in the pre-sentence report, there's not one thing in there that says, oh my gosh, what did I do to that girl? I wish I could help. I wish I could take it all back. I wish I could give her
3 words. She touched me.
Yeah.
But you admitted to oral sex with her.
And he called her the little accuser. That
I don't recall
Just-
saying nothing like that. I would never say nothing like that. And I actually, on the pre-sentence, I don't know if she wrote everything down, but I did.
They do.
Yeah. But I did.
They're real good about it, and they're real fair. The probation office
The
isn't
whole time I
about,
was there.
listen, when I speak, stop, okay? The probation, it's a point I want to make. The probation office has a rich history of being fair. We have a 93% success rate for our probation. You think they're working against you? No, they're trying to get you across the finish line successfully. So don't say it's their fault, sir. They do their job accurately, and they take great pride in success in probations, people making mistakes, fixing it, and moving on and being the best they can be. So
And Mr.
don't
Deuce-
go toward the probation office is dishonest when you got two separate sets of statements made to me under oath at the plea hearing, and then here in the pre-sentence report, your words are 180 degrees different. But you do say the right things in this letter. No, I was wrong. I take accountability for my action. I was going through a rough time in my life. Welcome to the world. Boy, don't we all? I mean, there are certain things that, with the difficulties we all have every day in daily life, some difficulties affect our clear thinking. Well, it's pretty clear. There's drinking, and then drinking. Was this at your house?
Yes, sir.
Yeah. Well, who's responsible for applying alcohol for that? You were. Okay. The pre-sentence report also states the mother of the victim. My daughter was supposed to be at a sleepover. You were pouring the alcohol like they were grown at a bar. And this event has mentally impacted my daughter. There's something else here that's in here in this pre-sentence report, but it's not. You know what it says. You've read it, and it's not a good thing about your reputation. Anybody else have anything to say? Mr. Ardoin, anything you would like to add?
Just wanted to say I apologize about everything to the mother, to the victim.
Yes, sir.
No, I never meant for anything to happen. No.
That's not, well, this says you admitted to intentionally or knowingly doing this,
I admitted to
committing sex, so oral sex.
under the influence. No, I made bad decisions. I made bad choices.
Well,
And I regret it all.
let me just say that these sorts of crimes in this court generally result in the highest form of punishment. And you were looking at this case at no less than 2 nor more than 20 years confinement in prison. And juries regularly give the maximum when they believe the crime has been committed. And this court does as well. Here is the cap. Y'all agreed on a cap. The highest that the court can set is 5 years in prison based upon the agreement. All right. I'm going to follow this agreement and find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second-degree felony of sexual assault, and I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. You will also be required to register as a sexual offender. Those are laws the state of Texas requires. Failure to properly register can result in further prosecution for the requirement of failing to register as a sex offender. Do you understand what has happened today, sir?
Yes, sir.
I just wished you would have had self-control, because you say good things, but yet your actions were different.
That's my past actions, and I guarantee you, I'm not that person anymore. I'm not.
Good. That's good. But well, there's an old saying, what's in the past is never really in the past. It's still there. It has to be accounted for. Okay. That is all. Thank you.
Judge, the victim's mother would like to do an allocution, if it's all right.
Hold on, sir. Before you leave, Come forward, please. I'm sorry, ma'am, your name and how you were related to the complainant here.
The little
When you
accuser, she prepared a statement because she cannot mentally hold it together enough to come in here and do it herself.
Yes, ma'am.
We believe the defendant possibly took a plea deal because the defendant does not want people to know how physically and mentally damaging by your disgusting behavior. I think all the time the defendant could have stopped himself. The time the defendant could have changed the course of this sick behavior. My mother has always shielded me from sick people like the defendant. The defendant told his daughter to have her friends come over for a Christmas party. I was excited to be at that moment. I was excited to be celebrating years of accomplishments. The defendant didn't go buy snacks and pizza and popcorn for us. The defendant went straight to the liquor store. The defendant didn't stop there. Once all the girls arrived at the defendant's apartment, the defendant began to pump all of us full of liquor. The defendant knew we were legal age to consume alcoholic beverages. The defendant gave all shots after shots after shots of liquor. You see how many times you should have stopped? I'm a 110-pound girl. It doesn't take a lot of liquor for me to feel the impacts of impaired coordination, balance, experiencing drowsiness, and sedated. The defendant separated me from the other girls. The defendant sent the other girls to the store. While the other girls the defendant sexually assaulted me. The defendant began to beat on the door. And you told my daughter you would kill her if she said anything to anybody. The defendant threatened me. In between of those mental breakdowns she goes through all the time from what you did. There are methods to accurately explain to you how this assault has forever changed my life. I will have to live with this for the rest of my life. Years when you get out. Pass the probation. People like this don't just rape one person and stop.
No way, man.
Sir, this is her time to speak. You've had your opportunity, sir. You can leave now, sir. You have been sentenced to prison. You are a convicted sex offender. You are taken into custody to serve your sentence. That is enough, sir.
Over here. Oh, man, over here.
All right.